April 2025 series because it is a bit harder as compared to the November series because it is a receipt and receipts are normally harder. So professional ethics 2025 April. Let us start with the questions. So question 1 says that Justin Lexon is the managing partner of Lexon and Company Associates based in Nairobi, Kenya. Some 5 years ago, he represented Kokoto Ngumu, the administrator of the estate of Kotu Kora, who is the deceased person, against Darkstore International in a claim for negligence and wrongful death attributed to carcinogenic ingredients in a product by the company. So the suit was filed in the United Republic of Nuts, where the corporation's parent entity is registered, and where the subject product was manufactured. The matter was settled through an out-of-court agreement that contained broad non-disclosure provisions that prohibited sharing any information regarding its terms with third parties. In an interview with the Daily News, a leading newspaper in Kenya, Justin stated that it was due to his skillfulness and versatile nature that the corporation compensated his client, Kenya shillings 563 million. He also pointed out that his client was willing to settle for much less, but his extensive experience litigating and negotiating such negligence claims resulted in him prevailing upon Kokoto on the need to push on and in the company willingness to settle the claim at a higher amount. Backed by the disclosures, Kokoto writes to the advocate Lexon requiring that he retracts the statements relating to the matter as reported in the Daily News. Lexon responds by stating that there was no wrongdoing on his part given the substantial passage of time from when the matter was settled and compensation made. So you'll be required to answer the following questions, supporting your answer with any relevant statutory or regulatory provisions or case law. Evaluate whether Advocate Lexon is guilty of professional misconduct, and the question carries 4 marks. The Kenya shillings 567 million compensation was deposited into the account of Advocate Lexon by the company, who then transferred the amount less part legal fees and disbursements to Kokoto's bank account. Part of the legal fees and disbursements remained unsettled. Discuss the various circumstances that can permit the disclosure by Advocate Lexon of the amount received by him and the funds that he eventually disbursed to Kokoto to third parties. C. Suppose Kokoto files a complaint under the Advocates Complaint Commission (ACC) against Advocate Lexon alleging professional misconduct by disclosure of the amount of the settlement and the intricacies involved in the prosecution of the claim and its settlement. Discuss the ACC's option upon receiving the complaint. Support your answer with any relevant statutory or regulatory provisions or case law. 6 marks. D. You are supposed to explain the rationale for the prohibition of disclosure of privileged information obtained by an advocate in the course of legal representation in the Kenyan society. Then lastly, E. From a marketing and advertising perspective, the conduct of Advocate Lexon amounts to prohibited touting and solicitation of clients. In your view, why do regulations prescribe advertising that constitutes touting and solicitation by advocates? So as usual, we usually read out the question in a way that now we will understand so that we answer questions in a way that is expected. So briefly, you're told that there is an advocate known as Justin, and 5 years ago, he represented a client known as Kokoto Ngumu, the administrator of an estate of Kotu Kora. And he represented this administrator against one company known as Darkstore International in a claim for negligence and wrongful death. So the matter was settled through an out-of-court agreement, but now Advocate Justin appears in a Daily News, leading newspaper in Kenya, saying that it is due to his skillfulness and versatile nature that the corporation compensated his client Kenya shillings 567 million, and he also pointed out that the client was even willing to settle far much less, but his extensive experience in litigation now made him to push the company to settle the claim at a higher amount. So this part it disturbs Kokoto Ngumu, and it decides to write to Advocate Lexon requiring that he retracts the statement. So the first question You're supposed to answer your answer with supporting argument on whether Advocate Lexon is guilty of professional misconduct. Yes, Mr. Chedwick, maybe we can try out all the questions so that we read the marking scheme in a collective manner.
Okay. Perhaps maybe we should try the first question. Well, I'll start by the definition of a professional misconduct. So, when I start with that definition, professional misconduct basically is the breach of the ethical standards and legal duties that govern the conduct of a profession. So, the statutory provision that I'll go with is I'll look at SOPEC, which talk about SOPEC 6. We talk about the confidentiality bit, and also talk about an advocate has a duty not to disclose any information without the client's consent. So the advocate's act of disclosing the amount that was awarded to him without the client's in prior consent is a breach, because also Section 134, the Evidence Act, also provide for confidentiality bit, where advocate should not disclose information that the client's consent. So, in terms of the relevant provision, I'll go with that. We're looking for case law. Case law still I'm not really conversant with the case law right now, but the governing provision of the SOPEC and also the advocate, and also talking about SOPEC 3, the competence and diligence of advocating handling client matters. It will be evident that his act of disclosing amount to professional misconduct, and this is clearly evident from the fact pattern that you've read, and it shows how he went ahead to on a live session to disclose what was awarded to his client without his client, so he didn't act in a competent and diligent manner expected of the standard of an advocate. That's all I can say for question A. Let me read question B and then respond.
Welcome, Madam Mukami. Because you do not have the advantage of reading out the question, we will allow Mr. Chedwick to take the stand so that you can go and answer the second question of it as we start reading the facts. But maybe Mr. Martin, before Mr. Chedwick, considering the first route that I stated, that we can read the marking scheme wholesomely, it is important we do part A, question and answer part, because you realize that Once you see the marking scheme, you will know how to frame such kind of answers, and it will make a huge impact as compared mixing the same with other parts of the question. So let us first deal with part A. Have you answered the way the examiner usually expects a student to answer? So whether Advocate Lexon committed professional misconduct, the direct answer is Advocate Lexon is likely guilty of professional misconduct. So 1, there is breach of advocate-client confidentiality, and this one you correctly captured the same. And the statutory backing is that under section 134(1) of the Evidence Act Cap 80, an advocate may not, without the client's express consent, disclose communications made by or on behalf of the client in the course of the retainer, the contents of documents encountered during the retainer, or advice given to the client during the retainer. So that is important. The scope of the confidentiality extends to communications, the content of documents, and even the advice given to the client during the retainer. So the advocate is exposing what he told Kokoto in a way of an advice. So that is prohibited under section 134(1) of the Evidence Act. So Lexon disclosed both the settlement amount and Kokoto's willingness to accept a lower amount. The latter was plainly confidential information communicated in the course of the retainer. There is no indication that Kokoto expressly consented to publication. The exceptions for communication made in furtherance of an illegal purpose or facts showing subsequent crime or fraud will not apply. Then you move the examiner to point number 2, because the question carries 4 marks. Confidentiality survives termination of the retainer. Lexon's argument that 5 years had passed is legally unattainable. Section 134(2) of the Evidence Act expressly provides that the protection continues after the advocate's employment has ceased. Confidentiality is therefore not extinguished merely by settlement, payment, or passage of time. Point number 3, breach of the settlement agreement. The settlement contained broad non-disclosure provisions prohibiting disclosure of its terms to third parties. By publicly stating the compensation amount, Lexon disclosed a term of the settlement to a newspaper. Subject to the agreement's precise wording and governing law, this could expose Kokoto or Lexon to contractual consequences and undermine the finality of the settlement. Even if Lexon was not personally a party to the agreement, his professional duty to preserve information obtained during the retainer remained applicable. Point number 4, improper publicity and use of client information for self-promotion. Lexon used the confidential settlement and Kokoto's negotiating position to advertise his supposed skills, versatility, and experience. An advocate must preserve the client's confidence and dignity and must not exploit confidential client affairs for personal publicity. Such conduct is inconsistent with the standards expected of an advocate and is capable of amounting to professional misconduct under the disciplinary framework of the Advocates Act Cap 16. It may also have prejudiced Kokoto by revealing that he had been prepared to accept substantially less. So conclusion is that Lexon's disclosure were not justified by the lapse of time. By revealing the settlement amount, his client's confidential instructions and negotiating position without express consent, he likely breached the following: statutory advocate-client confidentiality under Section 134 of the Evidence Act, the settlement's non-disclosure obligations, and his professional duties of confidentiality, fidelity, and proper conduct. So he should retract the statements, request correction or removal by the newspaper, cease further disclosure, and apologize to Kokoto. Kokoto may lodge a disciplinary complaint under the Advocates Act and, depending on the settlement terms and resulting laws, pursue appropriate contractual or civil remedies. So we have been in a position to see how the examiner expects you to answer such a kind of a question. Because you start with the position, is there any professional misconduct? The answer is yes. So Mr. Chedik, you are in a position to identify various SOPEC rules, of which it is also highly encouraged because it is the same content. But remember also to state the exceptions there too. Then you link your points to the fact sheet. We have seen how we link to the fact sheet. Then we have seen how we give a conclusion to the same of the various breaches that amount to professional misconduct. and that is the position where the examiner will expect you to score the 4 marks. Remember, many students will only summarize it and the question carries 4 marks. So examiner is expecting for you to reveal various acts of professional misconduct arising. Okay, so from the answer you realize that even the agreement itself had a non-disclosure clause. Okay, you have seen that even the advocate himself is using social media to advertise using the details of a client, okay, which is prohibited under the Advocates Marketing Rules of 2014. We have also seen that the advocate for professional misconduct part is disclosing an information that he used during the period of a retainer with a client, and that way you will score the total 4 marks without any objections. So that we now go to part B of the question. The Kenya shillings 567 million compensation was deposited into the account of Advocate Lexon by the company, who then transferred the amount less part legal fees and disbursements to Kokoto's bank account. Part of the legal fees and disbursements remained unsettled. Discuss the various circumstances that can permit the disclosure by Advocate Lexon of the amount received by him and the funds that he eventually disbursed to Kokoto to third parties. You're being told that this compensation amount was deposited into the account of the advocate. He decided to transfer this amount, but he deducted legal fees and disbursements to Kokoto's bank account. Now, part of the legal fees and disbursements remained unsettled. Now, the examiner expects you to do the following. Discuss the various circumstances that can permit the disclosure by Advocate Lexon of the amount received by him and the funds that he eventually disbursed to Kokoto to third parties. 4 marks. Mr. Chedik, because Madam Okami will go next in question number 2.
Okay, so first of all, let's talk about spec 4 and 5 that basically discuss professional fee and the client's duty to handle the advocate's duty to handle the client's funds. So this question basically is asking circumstances that can permit the disclosure by Advocate Lexon of the amount received by him. I think the last class that we had was talking about lien or lien that allows an advocate to hold client's documents if he has not been compensated. But let me talk about the various circumstances that permit the. Maybe you can scroll up so that you can look the facts and try to marry to the question. So he also pointed out. Okay, if you read that in an interview with Daily Newspaper, a lady, Justin stated that it was due to his skillfulness and versatile nature that the corporate compensated his client 567 million. He also pointed out that his client was willing to settle far much less, but his extensive experience litigating negotiating such negligence claim resulted in him prevailing upon Kokoto on the need to push on and in the company willingness to settle the claim at higher amount. So clearly you can see him saying that his client Kokoto was willing to settle far much less of the amount that supposed to be paid. So talking about him, and also I would look at also taxation bit that we also did. To respond, but the circumstances that allows, you can scroll now back to the question so you can see that permit disclosure. Oh, now this marries with the first question as well. On section 136 of the Evidence Act, on when an advocate can disclose let's see, number one is on circumstances when can lead to disclosure of information. So that is the breach on the confidentiality bit. So we said the first one is when there's a furtherance of an illegal act with the client, which is not evident here, and also with the consent of the client. So unless Kokoto had agreed to that, advocate Lexon can disclose the amount that he received. Basically, I'd look at those two instances when there's that privilege of disclosing the information received by the advocate from the client. I look at it in that context.
Thank you, Mr. Chadwick. So we'll weigh your answers against the 4 marks with the marking scheme. Welcome, Mr. Stephen. So, Mr. Stephen, because you have joined now, you will be the one tackling question number 3, because question number 2 will be tackled by Madam Okami. Then we reveal the marking scheme for us to make a swift progress. So, Mr. Chadwick, let us compare your answers against the marking scheme. We see whether you could have scored the 4 marks.
Sorry. Hi, because I don't have I've just joined.
Okay.
May I remain a listener for today? Kindly, yeah?
Yes, Mr. Stephen.
It's a request, yeah.
Yes, Mr. Stephen. And maybe a rider, we don't disclose the paper that you have to do in the morning or the series, and this is deliberate, because we want to see the shock from you on spot, because that is the same thing that will happen during the examinations, and you expect everyone to be prepared at this time. So that this is deliberate, it is not a pre-planned session from you. It is an ambush.
A quick one,
Yes.
Because I know I am really kind of really wanting to know how to prepare for CLE, yeah? Hello?
Yes, Mr. Stephen, you're audible.
I just wanted to know the rules of the game, so that even as I come on board, I know how to fit in. I think I'm doing this with all your honesty, so that at the end of the day, I am up to the speed.
Thank you, Mr. Stephen.
Will I be taking you too much of your time? I don't want to interrupt the session.
No, you're not taking much of our time. In fact, it is a guidance. So in these sessions, we usually analyze past paper made by CLE, and we are discovering a pattern on the hard questions, the procedural questions, and how to answer CLE questions. That is the motive. The motive is not to expect a question to be repeated in our series. No, that is not the game. The other thing of the game is that we have strict timelines. We have 4 to 6 a.m. like this session. Then we have but that is flexible, 7 to 8 p.m. or 6 to 8 p.m. so that we maximize on time, but we must disclose that during daytime. Then the other rule of the game is that we usually hear out your attempt, then we read out the marking scheme to avoid a situation where you will not appreciate the marking points if you have not understood the question and listened out to your argument. The other rule of the game is that when we discover there is a detailed procedure, like the way I did, we are answering a question, but you realize the examiner is asking about extradition treaty, but tied on one act. Remember, there are two acts on extradition treaties, but he wants for a specific act of parliament. Now, the question that you ask yourself, what if now the examiner asks you on the extradition procedure for the other act? So we usually break down such procedures into a webinar, and now we do a webinar all together of us, so that we appreciate how to deeply answer a procedural question that at least, Mr. Steven, up to that point you have realized the rule of the game. When it comes to procedural questions, we deal with them separately because this requires a detailed answer, because I realized there is a confusion for civil appeals, criminal revision. So we did a webinar, but I'm yet to present. I'll notify you. There is a full document that I did, detailed research inclusive of drafting. Look, this is where you start from chief, you go to high court, you go to court of appeal in civil, you go to criminal. This is what is required, so that at any given time you are not confused for any procedural question. For civil litigation, we realize that CLE has a pattern of testing the frequent applications. So we did a session on research major applications that will require your drafting. Is it garnishi? Is it third party? Is it injunction? All those applications have a similar webinar, and the same is due for presentation. At least now, Mr. Martin, you can be in a position to appreciate now these sessions.
Thank you. One more question. You said you normally meet between 4 and 6, isn't it? In the morning?
Yes, in the morning, every day.
The other time, when did you start meeting for this yearly?
We began before orals. In fact, I can send you to our YouTube channel, Kenyan Wakili. That's where you'll find all other years that we have done the same module.
Okay.
Yeah, it was deliberate so that we have to utilize the maximum duration and not be tied by orals.
That's okay. Let me not take much of the time because I respect order. Kindly call. I will talk later, please. But proceed. Kindly, I request. Thank you. Thank you, sir.
Thank you, Mr. Stephen, for your clarification. I've seen also Mr. Martin has joined. Yes, Mr. Martin, welcome. So as earlier provided by the directions, we are answering Mr. Chedwick's answer. Now again is the marking scheme. So we were to read question B, 1B, on his answer, and remember Mr. Chedwick has told us that question B is tied to question A above. So question B, the sums received and remitted through Lexon's client account are ordinarily confidential. Under Section 134 of the Evidence Act, disclosure may nevertheless be permitted in the following circumstances. Remember, Mr. Chedwick, you said Section 136 of the Evidence Act, of which it could have been fatal. With Kokoto's express consent, this one you captured the same correctly. Kokoto may expressly, preferably in writing, authorize Lexon to disclose 567 million received, the deductions made, and the net amount remitted. Disclosure must remain within the scope of that consent. And point number 2 is where disclosure is authorized or compelled by law. Lexon may disclose the figures pursuant to a court order, witness summons, taxation proceedings, lawful investigation, tax requirement, or inspection and audit of advocate's account. It should disclose only what the competent authority lawfully requires. 3. For accounting to the client and settlement of fees. Lexon must account to Kokoto for client money received, fees and disbursements deducted, and the balance remitted. If unpaid fees or disbursements are disputed, the figures may be disclosed in taxation of an advocate-client bill, fee recovery proceedings, disciplinary proceedings, or proceedings concerning the handling of client funds. Disclosure must be limited to what is reasonably necessary to establish or defend his claim. Illegal purpose and crime or fraud exceptions. This is where Mr. Chadwick now scores the other two mark. Section 134(1) all the way to A to B does not protect communications made in furtherance of an illegal purpose or facts observed by an advocate showing that a crime or fraud was committed after the retainer began. Thus, disclosure may be made where the receipt or disbursement formed part of fraud, money laundering, or another unlawful transaction subject to applicable statutory procedures. So the information cannot be disclosed to the media for publicity or self-promotion. Under Section 134(2) of the Evidence Act, confidentiality continues even after the advocate's employment has ended. Lexon must also observe the settlements agreements and disclosure provisions unless disclosure is permitted by its terms, authorized by Kokoto, or required overriding law. So maybe Mr. Chadwick, you are in a position to see when an examiner tells you the question carries 4 marks, you don't expect to give 2 points and expect the 4 marks. So it appears like CLE are mean with marks. So that try as much as possible to expand the points, but capture the ones that are eminent first. So for express consent is mandatory. The second part of it is where fraud is intended. That could have also formed a marking point on its own. Then you narrow down to at times disclosure can be authorized or compelled by the law. If you do a transaction on behalf of a client, KRA can email you to disclose such income accrued from such kind of transactions involving huge sums of money. So that is also a permitted disclosure because if you read the Pokamla Act section 18, the court can make an order for you to disclose, but that disclosure will still not go against the advocate's client privilege. So the court has an order to subject you to make a disclosure. So for accounting to the client and settlement of fees, so this is also another angle of disclosure. So remember, you have the duty to account to the client, and remember this is a third party now. What if now a third party writes an email to you for you to account on behalf of a client? Maybe they have instructions to act on behalf of Kokoto. So remember, once they prove they have this arrangement, then you have to account to the client on settlement of fees. This is typical when it comes to road traffic accidents where a family will come with village elders in your chambers to hear your accounting, and at that point you must account for them because the client has come in their presence. So that is an express consent from him. So Mr. Chadwick, you'll still progress to answering question C so that we invite other guests. Yes, Mr. Chadwick.
Okay, thank you so much for the answer. I've seen where I need to have corrected or where I went wrong. And my question in question A, we saw that there was that part of relevant statutory provision or regulation or case law. So perhaps in a question when you are asked such whether and you identify the provisions but you are unable to recall the case law, can you be penalized for that you don't remember the case law or you have not included it? Because question 1, I noted you didn't cite any case law on it.
I can say it is an exercise of discretion because even the question says or. So if you don't remember case law, in my view, will not be penalized unless the question says and. That's where, or directly with a case law, because the examiner could have lifted that question from a landmark decision. So they're expecting you to have also read the landmark decision. And you'll discover this in conflict of interest litigation aspect, because there is a separate webinar I did. So you discover that Uhuru Highway is an examination on its own. The other case of forgetting the landmark case of also on conflict of interest, is also an examinable situation on that. So the examiner will tell you with case law. So he's expecting to hear your answer on that. Yeah. So you can also try part C. Suppose Kokoto files a complaint under the Advocates Complaints Commission. So this is an open question, not tied to Chadwick, because this one is not tied to the factual matrix, part C, D, and E, so that I also encourage other members to also contribute. So Mr. Chadwick, now you can exercise discretion on these last questions. So suppose Kokoto files a complaint under the Advocates Complaint Commission ACC against Advocate Legson alleging professional misconduct by disclosure of the amount of settlement and the intricacies involved in the prosecution of the claim and its settlement. Now, discuss the ACC's options upon receiving the complaint. Support your answer with any relevant statutory or regulatory provisions or case law. 6 marks. So, do you have relevant statutory or regulatory or case law provisions that will help you to answer ACC's option upon receiving the complaint? What is the role of ACC upon receiving such complaints from a client or a former client? Any member. This is an open-ended question. The question carries 6 marks, so don't be mean with your options. Any member? What is the role of ACC and the options that ACC usually have when receiving a complaint? This is directly stipulated under the Advocates Act. There is a part of ACC and then there is a part of ADT. So you must know these are the roles of ADT. These are the role of ACC. This is how I structure my complaint when I'm approaching ACC, because an examiner can tell you to draft a complaint form. ACC has a form that you fill in. ADT, you do a replying affidavit, or you approach court using an affidavit and not court, the tribunal. There is an affidavit, you're allowed to annex documents, but ACC is tied to a specific form. You only annex supporting documents, but you answer the questions asked in that ACC form, around 3 pages. If it is to describe, you summarize your complaint into a paragraph. So, do you understand the role of ACC and the options that ACC has? Yes, Madam Mokami.
Thank you, Vicky, and good morning to everyone. If I may attempt to answer this question, I believe that for me, the first provision that I would cite is Section 53 of the Advocates Act, because now it provides for the Advocates Complaint Commission, and then some of the provisions that it does provide, or rather some of the options that the ACC has is one to, of course, to receive the complaint is one of the options. Number 2 is to now find whether the complaint has substance, and in the event that the complaint lacks substance, it can reject it, and in the event that the complaint has substance, then it can adopt the complaint and now conduct investigations as to that complaint. And then the other option is they can recommend after doing all the investigations, and maybe perhaps they're not in the position to handle it, they can recommend it to the ADT, the Advocates Disciplinary Tribunal. I would also be keen to cite that ADT is provided for under Section 57, the Advocates Act. Another option that they have, I'm not quite sure, but I believe that they can also recommend punishment as to that effect, should they find that there is substance to the same. I also recall that they can also initiate negotiations between the parties that have been involved. Um, yeah, essentially top of my mind are those ones. And then the case law that I can recall is one that was on professional misconduct with Nelson Harvey. I don't know, for me, I would cite it, Ree versus Nelson Harvey, where I believe the ACC recommended him to ADT, or maybe, yeah, alongside those lines. I believe I would also begin to cite that professional misconduct is provided for under Section 60 and outline that it is one of the reasons as to why one can be subjected to ACC and ADT. Yeah, disciplinary tribunals. Thank you.
That's a very good answer, Mrs. Mukami. And any other member who could also have an additional point? I don't want to leave any member out, because to my satisfaction, that is a very good answer. You have supported your answer correctly.
The only issue that maybe I don't know whether we need to clarify is who is subjected to ACC and who is subjected to ATP. Is it necessary? But that's a question I'm asking. Thank you.
Oh yes, that's a very important point. Is there any distinction? Can you tell me that advocates are taken to ACC, DT? Because remember, the distinction will come out when there is senior counsels. They'll be taken to a special appointed committee by the Chief Justice. There is a special tribunal that hears senior counsel complaints. So in my view, any advocate can be taken to ACC and ADT. And maybe the other question that can also come next time, look at the pecuniary nature of it. Does ACC has the pecuniary capacity to issue fines beyond 200,000 or 100,000, or is there a cap stipulated under the Advocates Act, Section 53? This is also important because the value that is in this question is a bit higher, 567 million. So if it is a fine, we don't expect a lesser fine coming from the ACC. So, but you have correctly captured they say. Maybe Mr. Stephen, have I tried also to argue my point? So I believe we are all in the same page. So part C of the question, if you read the marking scheme, it reads as follows. Let us read the same. So options available to the Advocates Complaint Commission. The Advocates Complaint Commission is established under Section 53(1) of the Advocates Act, Cap 16, to inquire into complaints against advocates, firm of advocates, and their employees. Upon receiving Kokoto's complaint, it may take the following steps. It can reject a complaint lacking substance. Under Section 53(4)(a), if the ACC's preliminary consideration establishes that the complaint has no substance, it may reject it forthwith. That outcome appears unlikely here because the alleged disclosure concerns the confidential settlement amount, Kokoto's instructions and willingness to accept less, the strategy employed in prosecuting and settling the claim, and an agreement containing express non-disclosure provisions. These matters disclose an arguable breach of advocate-client confidentiality under Section 134 of the Evidence Act. That is point number one, option number one. Option number two, it can refer the complaint to the disciplinary tribunal, as Mrs. Mukami has told us. Under Section 53(4)(b) of the Advocates Act, where it appears before or after investigation that the complaint has substance and constitutes or appears to constitute a disciplinary offense, the ACC must refer it to the disciplinary tribunal for action under Part 11 of the Act. So if it appears that this constitutes a disciplinary offense, it will be referred to ADT. Because Lexon allegedly disclosed confidential client information for personal publicity, the ACC is likely to classify the matter as possible professional misconduct and refer it to the tribunal. The tribunal, rather than the ACC, will determine guilt and impose the appropriate disciplinary sanction after hearing the parties. So you are justifying the option that you want ACC to exercise, and then you link to the factual matrix whether that option is available to Advocate Lexon. Then you go to the next option. There is a case law here in the Republic versus the Law LSK Disciplinary Tribunal and another ex parte Leonard Gedoi Kamweti 2015. The High Court recognized that the statutory power to make the appropriate referral under Section 53(4) belongs to the ACC. So that clarified the power to make a referral. So option number 3 is ACC can notify Lexon and require an answer. If the ACC considers the complaint to have substance but not to constitute a disciplinary offense, it must, under Section 53(4)(c), notify Lexon or his firm of the particulars of the complaint and require a response within a responsible specified period. Procedural fairness also requires Lexon to receive the material allegations and a reasonable opportunity to answer the same. So that is also option number 3, require a response from Advocate Lexon. Option number 4 is to make an investigation and make an appropriate order or award. After the response period expires, it is usually 14 days. The ACC may investigate under Section 53(4)(d). For that purpose, it may summon witnesses, it can compel production of documents, it can examine witnesses on oath, it can receive the parties' submissions and take any other proper and necessary investigative steps. It could therefore require the newspaper article, interview records, settlement agreement, correspondence demanding retraction and Lexon's reply. After hearing both sides, it may make such order or award as it is just within its statutory jurisdiction. In Republic versus the Advocates Complaint Commission and another ex parte, Morris, Gishora and Njage 2015, the High Court affirmed the ACC's power to investigate and order reimbursement or compensation, but emphasized that it must remain within its statutory monetary and jurisdictional limits and observe procedural fairness. So that is the option number 4 on investigation and making an appropriate order or award. Then we go to option number 5, promote reconciliation or amicable settlement under Section 53(5). Where the complaint is not serious or aggravated, the ACC must endeavor to promote reconciliation and facilitate an amicable settlement. It might invite the parties to agree on a public retraction or correction, a written apology, removal or correction of online publications, an undertaking against further disclosure, and appropriate compensation where legally possible. However, deliberate publication of confidential settlement details for professional self-promotion may be treated as sufficiently serious to warrant referral to the disciplinary tribunal despite any apology or settlement. Option number 6 is to advise Kokoto to seek relief from the court. That's also an option from the ACC. Under Section 53(4)(e), if the complaint has substance but neither discloses a disciplinary offense suitable for the tribunal nor a matter the ACC should determine, the ACC must advise Kokoto that the proper remedy lies in court. This may apply to claims for breach of the settlement's confidentiality clause, substantial damages caused by disclosure, an injunction against further publication, or other contractual or civil relief beyond the ACC's jurisdiction. So conclusion is that the most probable cause is for the ACC to conduct a preliminary assessment and refer the matter to the ADT under Section 53(4)(b). Because unauthorized disclosure of a client settlement amount, instructions and negotiation strategy presents an arguable disciplinary offense. Nonetheless, the ACC may reject an unsubstantiated complaint, investigate a non-disciplinary grievance, promote settlement, or direct Kokoto to court, depending on the evidence and the relief being sought. So that was a very good attempt from Mrs. Mokami. so that now we can go to the rationale questions that CLE must ask us, and the rationales are borrowed from the SOPEC rule. Remember, if you read the full SOPEC rule, we have a video where we analyze the full SOPEC rule, rule by rule, everything. In fact, we read out everything in the SOPEC rule. You realize that there is a paragraph for rationales after the end of every prohibition. So if you read part D question, explain the rationale for the prohibition of disclosure of privileged information obtained by an advocate in the course of legal representation in the Kenyan society, and the question carries 2 marks. So maybe you can attempt this one. What is the rationale for prohibition of disclosure of privileged information obtained by an advocate in the course of legal representation in the Kenyan society? This is open to any member.
Maybe I can try on the issues of exception. When you talk about, let me try to explain it from a very general perspective. The client has come to you and he has given instruction based on something that he has committed. Up there you have got client privilege information. But if client is planning to furtherance of a crime, a fraud, or what have you, the client privilege provision ceases. And at the end of the day, you are supposed either to decline, and if any case you are an officer, you are a judicial officer, so you should be able to report. That is the way I would look at that particular question. Again, I would also look at it from what we call anti-money laundering provision, and this one on terrorist and anti-terrorism. So those are taken very seriously. At the end of the day, if any of those crimes are to be committed, then advocate client privilege ceases. And that particular time, as a judicial officer, you can do the necessary disclosure. Thank you.
Thank you, Mr. Stephen, but you are taking a dangerous path by starting with the exceptions. But I appreciate the fact that you told us from the word go that, hey, look, that is the question, but I am giving out exceptions. I appreciate. Ms. Mukami, then Mr. Chadwick.
For me, my answer would be the rationale is just to ensure that there is open communication between the advocate and the client, and to preserve the public confidence when it comes to the relationship, and ensure that the confidential information is not revealed. The client is not focused to the extent of the disclosure, as opposed to now being open with the advocate. Thank you.
Thank you, Ms. Mukami. Mr. Chadwick.
Okay, so the rationale, just to add on what Ms. Mukami said, is to also to promote public trust in the legal profession, considering the advocate is duty to the client, duty to the court, and duty to the fellow advocates. So the first thing is the client would want to trust an advocate who want to disclose his information to the other party, such that it will make his case to be a bit on a shaky ground. So the first thing is we look at SOPEC 7, it's on confidentiality, and it clearly outlines the reason why advocate should use the information received, and also this promotes the aspect of fairness, where a client wants to be open and just to know that the advocate will not misuse the information received to against his advantage, because this information that are very confidential and to assist the client in the accessing justice. And also, if you look at section 134, that also provide for corroborated section 7 confidentiality. That's what I can say.
Thank you so much, Ms. Mokami, Mr. Stephen, and Mr. Chedwick. Because part E also is a rationale question, let us also attempt the same so that we read the marking scheme in a collective manner from a marketing and advertising perspective. The conduct of Advocate Lexon amounts to prohibited touting and solicitation of clients. In your view, why do regulations prescribe advertising that constitutes touting and solicitation by advocates? 4 marks. What is the rationale of limiting advertisements, including touting and solicitation by advocates? 4 marks. Yes, Ms. Mokami?
Sorry, Vicky, I forgot to put my hand down. But I think out loud, I believe it is one to preserve the constituents of the legal profession, because now it prevents an instance of let me go after another part. Let me structure mine.
Okay, that is well captured. Any other member? What is the rationale in your view? Why do the regulations prescribe advertising that constitutes touting and solicitation by advocates?
I don't know whether you can make an attempt, Maureen, but when you talk about the legal profession, just unlike any other profession, it has its own regulations. For example, if you look at the Advocate Act, it stipulates how an advocate is supposed to conduct himself. I think that is number one, the professional also ethics surrounding the legal practice. So when you talk about advertising, it is prohibited, and if it is to be done, the general advertising, there is specifications on what you need to do in terms of the signposts and everything. So that is the way I would look at it. It's not just an ordinary profession, it is a profession that has its own ethical regulations. I don't know whether Theodore.
Yeah, you're on track, Mr. Stephen. Thank you for that attempt. Mr. Chedwick?
Okay, so the reason also this regulation into place, I'm thinking out this first to prevent also advocates from disclosing previous matters that they have had and have successfully managed to win, such that you see from this fact pattern, Lexon is saying that he has experience in this area, and now to the extent of disclosing the amount that he has won in this case. The reason why it's regulated is to prevent such overlap on the advocate's part to the extent of disclosing previous matters that the advocate has had. And also, the second rationale is also to ensure that the advocate sticks to his area of expertise and specialization, and not to mislead clients that they can handle a matter when they don't have the relevant expertise in that area. So, for instance, let's say advocate Lexon is experiencing commercial dispute and constitutional matters. So, the advocate might mislead client that is also familiar in issues to do with the family law matters, when in essence that he doesn't have the expertise in that area. So that's why there's that regulation to ensure that the advocate sticks to their area of specialization and avoid misleading clients. Thank you.
Thank you so much, Mr. Chadwick. So we'll put your answers into the test. And is there a way that advertisement is also likely to be attributable to undercutting? Is there any intermarrying provisions when it comes to privilege information to the constitutional rights of an arrested person or accused person? Is there a general way of looking at various marking points that the examiner will also be expecting to hear from your answer? So let us see what the examiner expected in part D and E on rationale questions, so that we take caution on how we approach such kind of questions. So this is question number 2. Question number 2 was on lien, so we'll get quickly into question 2 so that we will have tackled also on liens. So the rationale for prohibiting. So let us start with rationale for advocate-client privilege. The prohibition under Section 134 of the Evidence Act, Cap 80, serves two principal purposes. Promoting full and candid communication. This was captured by Mrs. Mokami. So Mrs. Mokami correctly captured that you are promoting full and candid communication because clients must be able to disclose all relevant facts to advocates without fear that their confidences will later be revealed. Full disclosure enables advocates to give accurate advice and conduct effective representation, thereby promoting access to justice and the proper administration of justice. That is one principal purpose of the prohibition. The second angle of it is on protection of trust, privacy, and the right to legal representation. So confidentiality preserves public confidence in the advocate-client relationship, as Mr. Chadwick told us, public trust towards the legal profession, and protects the client's privacy and legal interest. The duty continues after the retainer ends, otherwise clients would withhold information, and the integrity of the legal profession and justice system will be undermined. The privilege belongs primarily to the client, not the advocate, and may generally be waived only through the client's express consent, subject to statutory exceptions such as communications made in furtherance of an illegal purpose. This is where Mr. Stevens' answer is appearing under. So the exceptions is by the way, but not the main answer that the examiner was expecting. So also take note that I have combined various marking points into 2 points. It can be dangerous because the examiner can assume that you have 2 marks. So promoting full and candid information, communication, that can be a mark. You can protect trust, that is also a mark. You can protect privacy. You can also protect the right to legal representation as enshrined in the Constitution. That can be able to award you 4 marks, but the question carried 2 marks. That's why I combined the 2 answers. So if you look for the rationale for prohibiting touting and solicitation, so advocates may advertise only within the limits prescribed by the Advocates Act and the Advocates Marketing and Advertising Rules of 2014. Touting and direct or indirect solicitation are prohibited principally because they, 1, Protect the dignity and integrity of the profession. Legal practice is a profession involving public trust and the administration of justice, not merely a commercial trade. Aggressive solicitation, boastful claims, and using confidential client outcomes for self-promotion lowers the professional standards. So that is one, protection of the dignity and integrity of the profession. Point number 2 is protect clients from exploitation and undue influence. Persons seeking legal assistance may be bereaved, injured, accused, financially distressed, or otherwise vulnerable. So touting may pressure them into retaining an advocate without making a free and informed choice. That's also a rationale. Rationale number 3 is to prevent misleading claims and unfair competition. Statements claiming superior skill, guaranteed results, or exceptional success may be unverifiable and create unjustified expectations, as Mr. Chedick told us. So restrictions promote fair competition based on competence and reputation rather than sensational claims or purchased access to clients. That is also a rationale. Prevent misleading claims and unfair competition. Rationale number 4 is we have preserve confidentiality and public confidence in justice. So using a client's settlement, disputes, or personal circumstances as advertising may breach confidentiality and commodify the client's case. Prohibition reassures the public that advocates will exercise independence, discretion, and fidelity rather than exploit client affairs for commercial gain. So as a recap, the rationales for prohibiting touting and solicitation is protect the dignity and integrity of the profession. It protects clients from exploitation and undue influence. It prevents misleading claims and unfair competition. It preserves confidentiality and public confidence in justice. So accordingly, Lexon's boast that his skill secured 567 million, coupled with the disclosure of the client's willingness to accept less, risks misleading comparative self-promotion, exploitation of confidential information, and indirect solicitation of similar placed clients. So you have seen how you will exercise your discretion when it comes to giving such kind of answers. It is not tied upon any provisions of the law. It is just in your own view, because even the examiner told you to use your own view in answering such kind of questions, but tie your view to reasonable provisions indirectly provided in the law. Competition Act, etc., confidentiality, public confidence. Those are the marking points that the examiner will be expecting. So that we quickly jump to question number 2. Advocate Daudi has been undertaking some legal litigation on behalf of his client, Solomoni. Though they had agreed on a legal fee of 100,000, Solomoni had not made any payments for the last 2 years. Efforts on the part of Daudi to recover the same, considering that the cases were completed, have proved futile, though he has a pending bill of cost. Daudi is also on the panel of the Housing Bank of Kenya. He has just been instructed by the bank to register a charge in its favor over a loan that Solomoni intends to borrow. When he prepared a professional undertaking to the advocates for Solomoni, Fresh and Company Advocates, he did not say anything about the 100,000 that Solomoni has been avoiding to pay. At the end of the transaction, he has disbursed all the money except for the 100,000, which he claims is his lien. Freshie and Company Advocates has threatened to enforce the professional undertaking against Advocate Daudi. A. Citing the relevant provision. What is the nature of an advocate's lien? 2 marks. B. Is Advocate Daudi entitled to retain 100,000? C. What is a professional undertaking, and is Daudi in breach of the same? 4 marks. So we usually revisit the question in a way that we will understand, so that we appreciate the question. We have a person known as Advocate Daudi, who has been undertaking some litigations on behalf of his client, Solomoni. So although they had agreed on a legal fee of 100,000, Solomoni, the client, had never made any payments for the last 2 years. And the efforts to recover the same, considering that the cases were completed, have now proved futile from Advocate Daudi, although he has a pending bill of cost. So it is still pending, the status. So we are also told that Daudi is also on the panel of the Housing Bank of Kenya, and he has just been instructed by the bank to register a charge in its favor over a loan that Solomoni intends to borrow, the same client who has a debt. When he prepared a professional undertaking to the advocates for Solomoni, Freshie and Company advocates, he did not say anything about the 100,000 that Solomoni has been avoiding to pay. At the end of the transaction, he has disbursed all the money except for the 100,000, which he claims is his lien. Freshie and Company advocates have threatened to enforce the professional undertaking against Advocate Daudi. Now, citing the relevant provision, what is the nature of an advocate's lien? Is Advocate Daudi entitled to retain the same? And what is a professional undertaking? And is Daudi in breach of the same? So it's an open-ended question. You can select any kind of question you want to attempt, but I usually advise we start first with part A, then we exhaust. This will be the last question so that we have another session on professional ethics. Yes, Mr. Chedwick.
Okay, so the relevant provision is Section 52 of the Advocates Act that generally gives the advocates the right to retain clients' documents or funds to when there's a pending deal when the client fails to fulfill his or her obligations. So basically, I'd start by defining what is a lien, and basically the nature that it empowers the court to declare an advocate entitled to a lien on the property recovered or preserved through professional instrument and efforts. So the court will order the taxation of cost and direct payment of raising money out of the judge property to pay the advocate. So basically that's our response to that question.
Yes, you can proceed to other questions. That is due to time.
On question 2, Advocate Daudi is entitled to the lien, but on condition that he makes the application in the court that he had represented the client for the purposes of taxation and determining the amount that he is entitled to. And as I recall, the application will be made the Order 51 of the Poll Procedure rules for the purposes of taxation, that's by notice of motion applications. So yes, he indeed is entitled to retain the money, but the purpose of fairness, he had to make an application in the court that he did represent the client.
Okay, thank you. Can you proceed? Or there is also another member who wants to attempt. Mr. Martin, welcome.
Thank you. I'm just listening in. And I think I will agree with what my peers have said. And also, the right to that the advocate has to be able to recover the fee, and I will also make reference to section 45 that there is indeed a retainer agreement that has been put and it is enforceable. So I think I'll be able to make reference to section 45 to be able to enforce the agreement.
That's well captured, Mr. Martin. Part C of the question is also not answered.
Okay, maybe I can try part C. So part C, it has two parts. That is the definition of a professional undertaking. So basically, professional undertaking, these are promise made by an advocate or someone acting on the instruction of an advocate to a third party, and the same is to be relied by the third party in the fulfillment of an obligation on the part of the advocate. So, in instance, an advocate saying that his client that he pay a certain amount of money, and one distinguished feature of professional undertaking is binding. And it is dependent on the fulfillment of a future event. So, in the part of Daudi, let me just read the fact pattern to get that part. Yeah, so Daudi is in breach of the same because he did not disclose he did not give any disclosure to Frisch in company advocates that his client owed him some money in the same. And since the same was not made, so he's in breach of the same what goes out.
So thank you so much, Mr. Martin, Mr. Chadwick, and Mr. Stephen. So we can look at what the marking scheme provided in such a question. What is the examiner expecting you to answer? So if you are asked about the nature of an advocate's lien is a passive possessory right to retain a client's money, documents, or other property that lawfully came into the advocate's possession in the course of the retainer until the advocate's properly due costs are paid or secured. It is a right of retention, not ownership. It is dependent on the advocate's continued lawful possession, limited to costs properly due from the relevant client, and not ordinarily a right to sell, appropriate, or unilaterally apply the client's property towards fees. So remember, it is a right of retention, not ownership. It is a passive possessory right to retain a client's money, documents, etc. Under Order 52, Rule 4.3 of the Civil Procedure Rules, where an advocate claims cost, the court may order taxation or payment of the cost, secure their payment, and protect the advocate's lien. So, that is the nature of an advocate's lien as per the question. Citing the relevant provision, what is the nature of an advocate's lien? Just a general answer, 2 marks. Now, whether Daudi may retain the 100,000, 4 marks. What are the marking points? So no, not on the facts stated by the matrix. 1. The money was received for a specific transaction. Daudi was instructed by Housing Bank of Kenya to register its charge. The transaction money was therefore received in a specific capacity and for an identified purpose. He could not divert part of it to settle fees allegedly owed under an earlier and separate retainer. An advocate's lien is passive and does not ordinarily authorize unilateral deduction from client funds held for a particular purpose. This was affirmed in the case of Hall Equatorial Limited versus Titus Makano and Associates Advocates 2025. So that act of retaining unilateral deduction was not in accordance with what an advocate's lien is supposed to do. So the money was received for a specified transaction. 2. Solomoni was not Daudi's client in the charged transaction. In the present transaction, Daudi acted for the bank, while Fresh and Company advocates acted for Solomoni. His earlier fee claim against Solomoni did not entitle him to treat the bank's transaction funds or money payable under the professional undertaking as security for an unrelated debt. Further, the facts do not establish that the relevant 100,000 belonged beneficially to Solomoni rather than the bank or another transaction party. So Solomoni was not Daudi's client in the charged transaction. So, point number 3, no express right of set-off was reserved. So Daudi did not disclose the fee claim or reserve a right to deduct 100,000 when giving the undertaking. He cannot subsequently vary the undertaking unilaterally by asserting a lien. So 4, what is the proper procedure? Did the question require proper procedure? Let us go back, we see. So is advocate Daudi entitled to retain the 100,000? So the proper procedure is just an additional point because you have already outlined to the examiner. This is why he should not be entitled to the same. The money was for a specific transaction. Solomoni was not Daudi's client in the charged transaction, and that there is no express right of set-off that was reserved in the professional undertaking. So what is the procedure? Daudi should deliver an advocate client bill to Solomoni, file the bill for taxation under the Advocates Act and Advocates Remuneration Order if disputed, and recover the certified amount through the prescribed legal process. So Order 52 Rule 4.3 permits the court protect any valid lien while resolving the cost claim. Daudi must therefore release the 100,000 in accordance with the undertaking and pursue his unpaid fees separately. So what is the meaning of a PU and whether Daudi breached it? So the meaning is that a professional undertaking, as Mr. Chedwick told us, is a clear, unequivocal, and binding promise given by an advocate in the advocate's professional capacity to do or refrain from doing a specified act. It is given to facilitate reliance and completion of a transaction and binds the advocates personally whether or not the client later provides funds or instructions necessary for its performance. So the key terms is clear, unequivocal, binding, given in your professional capacity to do or refrain from a certain act, and it will bind you personally and even your employees as a law firm. So a valid undertaking should be clear and unambiguous, given by an advocate with authority, capable of performance, and relied upon by the recipient. So the court may summarily enforce an advocate's professional undertaking under Order 52 Rule 7 of the Civil Procedure Rules. In Henry Kipkorir Kimutai versus Wenda Ambrose Otieno, 2018, the court affirmed that an undertaking must be clear and unequivocal and that the advocate is personally liable for its breach. So the application to the question is that Daudi is in breach of his undertaking Daudi is in breach if his undertaking required him to disclose the entire transaction sum or the stated balance to Fresh and Company advocates without authorizing deduction of his previous fees. So his undisclosed fee claim does not qualify the undertaking. He may not introduce a new condition after the undertaking has been accepted, set off an unrelated advocate-client debt, rely on his client's default to avoid personal performance, or use a lien to defeat an express professional promise. So Fresh and Company advocates may apply under Order 52 Rule 7 for enforcement. The court may order Daudi to honor the undertaking within a specified period and permit enforcement against him personally if he defaults. He may also face disciplinary consequences because failure to honor a PU can constitute a professional misconduct. So the conclusion will be that Daudi must remit the withheld 100,000 in accordance with this undertaking. His remedy for unpaid fees fees lies in taxation and recovery against Solomoni, not unilateral deduction from funds held for the charge transaction. So that was a attempt in such kind of a question as what the examiner expected to hear from you. So I believe we have captured the nature of an advocate's lien. We have directly extracted the key terms. It is a passive possessory right to retain a client's money, documents, or other property. It is a right of retention, not ownership. It is dependent on the advocate's continued lawful possession. It is limited to costs properly due from the relevant client and not ordinarily a right to sell, appropriate, or unilaterally apply the client's property towards fees. So that will now mark the end of this session to allow people to prepare for the rest of the day. We will do the second bit of it. We must finish up our papers. Remember, we don't leave papers hanging. So in the evening, we can decide to do part B. But for maximum utilization, we had planned conveyancing in the evening because conveyancing requires a detailed approach to the same, so that we can now resume with professional ethics in the morning of tomorrow. So that marks the end of Professional Ethics Part A of 2025 April paper. Unless there are closing comments, I wish to end the session.
Maybe before you end,
And yes,
this by big biscuit between me and you,
okay.
Maybe you can call me and we discuss. I'm in class G, and you can see the timing is totally different. Hello.
True.
That we can agree on the mode of operations. Let's add the class, then we can discuss, because this is on record. I don't want to.
Oh yes. Let me end the recording.